Okay, good morning, everyone. Thank you for joining us for the Medical Board of California Panel A online meeting this morning. Just have some meeting formats and procedures to start with, and we will go ahead and I'll turn the meeting over to the chair in just a few moments here. Being that this is a WebEx meeting, though, we just have a few instructions to give out in the beginning. So we'll be taking roll call for participants for each oral argument at the start of each agenda item, just to make sure that everybody is with us before we do go on record and start the proceedings. So we ask that everybody who's right now in the attendee mode, you won't be able to speak until we do move you up as a panelist when your case is heard. Once all the panelists are present, the administrative law judge will go ahead and take over and conduct the oral argument. When the oral arguments have concluded, we will be allocating 30 minutes of time to do the closed session deliberation. Well, what that will mean is during the closed session, much like when people have to leave the room during a physical meeting, we will actually have to have everybody leave the online meeting. And before we have you leave the online meeting, we will announce what time to return. And during that time that the meeting is in closed session, if you try to return to the meeting, you will get a message saying that the meeting is locked. I have the WebEx event is locked. The host has restricted access to the event to those who are currently in attendance. We are going to stay on a very tight time schedule to make sure that the time that we announce is the time that we reopen the meeting so that you're able to rejoin the meeting for the next oral argument. You'll use the same link from the top of the agenda that you used to join this time. So again, at the time that we announce, you just go back to that agenda, click on the link again, and you will be able to rejoin at that time. And as I mentioned, we will be keeping a very close time schedule. I'll be announcing to the deliberators as time lapses to make sure that we are back at the time that we announce. So there will be no public comment during this meeting. And again, all attendees are unable to mute themselves unless they are promoted to the panelist role, which I will be doing as we call each case. So with that done, I will turn it over to the chair, Dr. Lewis, so he can go ahead and introduce himself and begin the meeting. Thank you.
Me now? Hello?
Yes, Dr. Lewis.
Oh, good.
Yes, Dr. Lewis, we can hear you. Go ahead.
I'm going to call to order the Panel A online meeting of the Medical Board of California. I am Ronald H. Lewis, MD, the chair of Panel A. The first order of business will be to establish a quorum, and we will do this by calling roll. When you hear your name, signify by saying "I" as you unmute yourself, and then go back to mute again. So let's have the quorum established. So could you please call roll?
Dr. Lewis?
Present.
Dr. Hawkins? Ms. Lupiano? Mr. Foreman?
Present.
Ms. Lupiano? Ms. Lupiano? Can you hear me? Yes. Hello? Mr. Watkins?
Here. Can you hear me? Here.
Dr. Yip?
Dr. Yip here.
We have a quorum.
Hey, you turn it back over to me. Okay, the quorum has now been established. I want to say that we all appreciate your patience on this maiden voyage of this virtual meeting. So hopefully from now on will be smooth sailing. But do remember that this is the first time we've tried this, or there may be an occasional glitch. Okay. Sean, who you just heard from, will be the timekeeper. He will keep us on schedule since we have a very full agenda today. I'm going to now ask that every time that you want to speak, you state your name for the court reporter, since she cannot see you physically. So I'm going to turn the meeting of the open session over to Judge Quorum Wong to guide us through the open session of this Panel A meeting. Judge Wong.
Thank you, Dr. Lewis. So, Madam Court Reporter, if we could go ahead and go on the record. So
Judge Wong, can I step in real quick?
Sure.
Mary Kate, is there an announcement you had to make?
No.
Mary Kate's headset isn't working, so I need her to get on another. I'm sorry, there's a microphone issue here.
You want me to go off mute, Sean?
Sorry, we're live here, Dr. Lewis.
I just wanted to ensure that we had given enough time, as this was our first roll call, to ensure that all of the members were here. So we have Dr. Lewis.
Yes.
Dr. Hawkins.
Yes.
Lubiano. Mr. Warmoth.
Here.
Yes.
Mr. Watkins.
Yes, present.
And Dr. Yip.
Dr. Yip here.
Thank you.
Okay, Dr. Wong, the floor is yours. Miss
Yes.
Judge Wong. I'm calling you Dr. Wong. It's Judge Wong. There you
Thank you. Not a problem. So let's go ahead and go back on the record. We are on the record before the Medical Board of California, Department of Consumer Affairs, State of California, in the matter of the petition for penalty relief of Zachary King Cosgrove, MD. That's MBC number 800-2018-042126, OAH number 2020-040-349. My name's Quorum Wong. I'm an administrative Office of Administrative Hearings. This is the date and time set for oral argument in the notice of hearing for oral argument in light of Governor Newsom's Executive Order N-29-20 dated March 17th, 2020. Oral argument is being held as a web event. And it looks like just the court reporter and I are appearing by video with everyone connecting by audio only. So even though we did just establish a quorum, I do need to establish a quorum for the record. And again, since the panel members do not have their cameras on, I ask that each panel answer audibly after I call his or her name. So Dr. Lewis.
Dr. Lewis, you'll have to unmute to respond.
Yes, present.
Okay, Dr. Hawkins.
Here.
Ms. Lubiano.
Here.
Ms. Warmoth.
Here.
Ms. Watkins.
Yeah. Yeah.
And Dr. Yip.
Here.
Thank you. The record reflect that a quorum is established. Next, I'll ask that the attorneys state and spell their names for the record, starting with the Deputy Attorney General.
Judge Wong, I need to go ahead and promote now all of the individuals involved with this case. So if you give me just 1 minute, I will bring them on. Brian Roberts, Dag, you're now in. Mr. Lear, you are now in. And Mr. Cosgrove, Dr. Cosgrove, you are now in. So you are all able now to unmute your mics and speak freely as Judge Wong calls upon you. Please continue, Judge Wong.
Thank you. So again, if I could have the attorneys state and spell their names for the record, starting with the Deputy Attorney General.
Thank you. Good morning. Brian Roberts here on behalf of the Attorney General and the people of the state of California. That's BRIAN ROBERTS. Thank you.
And Mr. Lear, if I could have you unmute and state and spell your name for the record, please. Mr. Lear,
you're on mute. Your microphone button is the bottom left button. If it's red, that means you're still on mute. There you go.
Thank you for that. Edward Lear on behalf of Dr. Cosgrove, who is also on the feed, and my name is spelled E-D-W-A-R-D, Lear, L-E-A-R.
Okay, thank you. And I see Mr. Roberts and Mr. Lear that you have connected by video, so I will note that for the record. And it looks like Dr. Lear is by audio only. Is that correct, Mr. Lear? Or excuse me, Dr. Cosgrove.
Dr. Cosgrove appears to be by video. I'm sorry, by audio only.
Okay, great, thank you. All right, so the board in this matter has issued an order of non-adoption of a proposed decision by an administrative law judge and has decided to determine the matter itself. The board has requested oral arguments and has expressly limited oral argument in this matter to the question of whether the proposed penalty should be modified. The following process and time limitations will apply. Respondent will have 15 minutes to make an opening argument, or I should say Mr. Lear will have 15 minutes to make a opening argument, and then the Deputy Attorney General will have 15 minutes for a response, followed by Mr. Lear having 5 minutes for closing arguments, followed by the Deputy Attorney General having 5 minutes for closing. These time limits will be strictly enforced. I'd like to remind the parties that arguments shall be limited only to the existing record and shall not exceed the scope of the record of duly admitted evidence. No new evidence will be heard. The panel may ask questions of the parties to clarify the arguments, but should not ask questions that elicit new evidence. I or any panel member may ask a party to support the party's argument by a specific citation to a specific part of the record. At the end of oral arguments by counsel, I will offer Dr. Cosgrove an opportunity to address the panel regarding penalty. If he elects to address the panel, I will place him under oath, and he will have no more than 5 minutes to address the panel. And this is optional. He has the right to do it, but it's certainly not required that he do so. And then finally, after our oral argument, the board will go into closed session to deliberate. So a decision will not be issued today, but will be issued sometime in the future. Oral arguments are being recorded stenographically by a court reporter who, of course, is at a different location than the speakers. Therefore, it's important that everyone identify himself or herself each time before speaking, and that they speak slowly and clearly. It's requested that you mute your microphone when not speaking, and of course, remember to unmute it just before speaking. And also, if you could keep in mind that the rustling of papers will pick up on the microphone and cause interference. And again, I want to remind the parties that arguments must be based on the existing record and no new evidence will be heard. Additionally, the board has already had the benefit of receiving and reading the parties' briefs, so that should be kept in mind as well. So with that, Mr. Lear, you may begin.
Thank you, Your Honor, and thank you. This case has been going on for a while, as you could all see from the procedural record. Most importantly, and the most important date for all to be aware of is December 7th, 2006. That was the date that Dr. Cosgrove was arrested in Rancho Mirage, but more importantly, for the purposes of this hearing, that is the date that he stopped using drugs and has been sober since then. That is going on 14 years, and it's a significant period of time. It was deemed significant, certainly by Judge Garrett in the hearing that we had before her, where Dr. Cosgrove was reinstated with the conditions of probation that are at issue today. So what we're not here to talk about today is whether he qualifies for reinstatement. He clearly does. That's been adjudicated. And as the panel and board is aware, Dr. Cosgrove has been practicing medicine and he's been doing great. He's been doing so great that he was deemed to be somebody that no longer has to be on probation and no longer has to be subject to the probation conditions. That's why we're here today. And in that regard, the argument from the board is essentially that that monitoring needs to continue to take place and that Dr. Cosgrove should continue to be on probation. That is belied by the evidence. To wit, there was testimony from, amongst others, Ms. Dvorak at the trial. Ms. Dvorak is with the medical board's probation unit, and she was subpoenaed to come in, and she testified unequivocally that Dr. Cosgrove no longer needs to be on probation. He doesn't benefit from that, nor do the people of the state of California benefit from that. And in that regard, I cite you all to the record where Ms. Dvorak identified that, one, Dr. Cosgrove has never had a positive result on his biological fluid testing, and then further opined that there was no reason for Dr. Cosgrove to continue being on probation. That's from the medical board itself. And we find that to be the most compelling of all the evidence that was provided, and so did Judge Garrett. Dr. Cosgrove testified, I'm looking to page 67 of the transcript, that his parent in who he is today, that he maintains his sobriety just based upon his self-discipline. That is exactly what the goal was out of the entirety of this process, and that is exactly what has happened. He further opined on page 68 that he did not think it was required for him to remain, to continue with counseling or therapy, for him to be emotionally stable and continue his emotional stability. Again, that was and is the goal of any probation. And Dr. Cosgrove epitomizes the successful product of the probationary conditions to which he was subject for the 4 years for which he was on probation. This is the goal. The goal is to help somebody like Dr. Cosgrove through probation conditions get to where he is today. To wit, he is somebody who is emotionally stable on his own. He's somebody who is sober on his own and is not somebody that needs any probationary conditions on a future going basis. The board may be aware from the record that Dr. Cosgrove is currently practicing in Bakersfield. There was testimony in the record from character reference letters about how well he is doing. The board may further be aware from the record that Dr. Cosgrove's family resides in Texas. And a big motive for Dr. Cosgrove being off is so that he can move from California to Texas in order to practice medicine in Texas. In order to qualify to be a Texas practitioner, it's critical that he be off of probation in California. That's what's underlying this great effort. So there are two things underlying it. One, he no longer needs the counseling, the therapy, the biological testing to which he's been subject. But two, and I'm not even sure it's two, it's probably more of a 1A, he wants to be with his family, and he's been apart from his family for 4 years. Again, grateful that he's practicing and has the privilege of practicing medicine. Very grateful about that. But nevertheless, he would like to go back to Texas to be with his family unit. That's what's driving this. And so in that regard, we believe that we've met the burden. We've met the burden, one, for reinstatement, obviously. Two, we met the burden in front of Judge Garrett for eliminating the probationary conditions. And three, we don't think that there's any compelling argument from the medical board as we go down the line that Dr. Cosgrove should not be able to be off of probation, because essentially he's earned it. He's earned the right. He's done great. He's had almost 14 years of sobriety. And that is as compelling as anything probably most of us have seen in regard to these proceedings. That's a long time. And so for those reasons, we submit that Dr. Cosgrove should, one, be off of probation, two, that Judge Garrett, an experienced judge, got it right, that unlike what the medical board stated in its brief, her conclusion was not based on pure speculation. Rather, she considered the evidence. She considered the testimony from Dr. Dvorak. She considered all of the paperwork that we submitted, including from Dr. Cosgrove's peers with whom he works, about the way that he is leading a stable, normal life and is worthy of being able to practice without being on probation. Thank you.
Thank you, Mr. Lear. Mr. Roberts, you may begin with your argument.
Thank you. So it is my position that the decision in this case does need to be modified, and that is that the petition for early termination should be denied. The respondent has not met his burden of proving rehabilitation, and he still presents a danger to public safety. First, one of the factors that must be considered when determining whether to reinstate a license or terminate probation early is the nature and severity of the acts and crimes here. And the nature and severity of the acts here cannot be overstated. The misconduct here is that the doctor was involved with 3 different female patients in a sexual relationship. Not 1, not 2, but 3 separate female patients. And that alone in itself is very, very severe misconduct. But that is not it. In addition to the sexual relationships, all 3 of those relationships also involved some sort of type of violence. In 2 of those instances, there was physical domestic violence. One, the doctor kicked and punched one of the female patients. In another, he roughly grabbed a female patient by the arm and threw a dangerous object at her, causing physical injury. And then the third episode involved threats and witness intimidation. In fact, the quote was, he told the patient, "You better kill yourself because that's going to hurt less than what I'm going to do to you." This is very, very serious conduct, very egregious conduct. And the case law is very clear: when acts of misconduct involve a high degree of moral turpitude, the proof of reform has to be overwhelming. And here, while Dr. Cosgrove has provided proof that he has shown some reform and some rehabilitation, the proof here is not overwhelming. All we have here is that he has merely complied with probation, that he's done what's been asked of him. He's done nothing more than that. He's not gone above or beyond his probation terms. He's not shown any further steps of independent reform outside of his probation that he has done to rehabilitate himself or reform himself. Thus, I think it is clear from the evidence that he has not met the clear and convincing standard that is required, let alone the overwhelming proof that is required due to the high degree of moral turpitude involved in this case. In fact, I think also his attitude towards his reform and his rehabilitation is very naive in certain respects. The respondent has no plans to continue his sobriety beyond what he testified at the hearing, other than just his own self-discipline, his own self-will. And while he has maintained sobriety for 14 years, as self-reported by him, in those 14 years, he's had some type of support system to help him do that. It's my understanding that he attended NA meetings prior to his license being reinstated and being placed on probation. And during his probation, he's been under monitoring where he has to call in. He has to get drug tested. So those were systems in place to make sure that he maintains his sobriety. If his probation is terminated early, we have no systems in place. He has no system in place. So we don't know at this point what his reaction or what his conduct will be if there are not those systems, backup systems in place to help him maintain his sobriety. Additionally, it is very clear from all of this misconduct that the doctor does have some type of emotional and anger-related issues. And while I do commend him for working through these issues in therapy, again, he has no program or no plans in place to deal with these issues beyond his probation term. So him not having any plans in place, I think, shows a lack of seriousness in maintaining his reform, and it still places the public in danger, the fact that he does not have any plans in place beyond probation. So most importantly, we have to weigh his desire to get his license back, or not to get it back, but to have it free of any type of probation, and the interest of the public and protecting the public and public safety. And I think probation needs to continue to make sure that patients are protected and that the public is protected. Because even as the doctor's two witnesses at the hearing testified, that the doctor maintaining his sobriety is by far the most important, the most key thing in making sure that he stays reformed and that the public is protected. If he does not maintain his sobriety, the probation monitor said that she wasn't sure if he would be a threat to the public or not. So it is important for probation to continue so that we can monitor the doctor and make sure that he maintains his sobriety. So in closing, I would ask that this decision be modified and that the petition be denied. Thank you.
Mr. Roberts, Mr. Lear, your reply, please.
Thank you, and I apologize in advance for the trash truck that, of course, chose now to come by. That said, there has been, through the record of this matter, evidence of professionals, mental health professionals, opining that Dr. Cosgrove is safe to practice and does not have a further need to be on probation. And I think the medical board is not being candid with respect to the evidence. One, we've already mentioned Ms. Dvorak of the medical board probation monitoring, who will opine clearly on pages 23 and 24 of the transcript that she has no hesitation in Dr. Cosgrove being off probation. But I think also it's important to look into the weeds in this case. In the trial in the August 2015 reinstatement hearing, there was evidence from a Dr. Christopher Tickner, who was a psychiatrist from Texas, who testified that he found no evidence to suggest that Dr. Cosgrove was a danger to the public, and basically released him from continuing psychological and psychiatric counseling. And I think that's compelling here in light of the argument being made by the medical board. Moreover, Dr. Kai McDonald, K-A-I McDonald, the psychiatrist who was appointed by the medical board and had to assess Dr. Cosgrove's psychological health, found that Dr. Cosgrove was safe to practice medicine with no additional restrictions or provisions, and that was in 2016. That's the medical board's own expert opinion, and that's documented by a letter on file with the medical board probation department in July of 2016. So to say that there's not any evidence or that Judge Garrett made a speculative decision it is just not consistent with what actually happened here. So this is not, as framed by the medical board, Dr. Cosgrove opining about himself that he's good to go and that he can self-discipline himself. That was a comment made by Dr. Cosgrove at the probation monitoring hearing that is buttressed and supported by mental health professionals that are throughout the record in this case. So this is not a Dr. Cosgrove that's gone rogue. There's plenty of backup for this. And so for all those reasons, we think that no, Dr. Cosgrove's not being naive. He understands the situation. Sorry about this. And that his attitude is good. He's worked hard to get to this point. His self-discipline is supported by the mental health professionals. Yes, we agree that the underlying misconduct was severe and inappropriate, but we're past that. That's not what this hearing is about. This hearing is about Dr. Cosgrove's rehabilitation. We believe he has checked all the boxes and ask that this panel uphold the decision of Judge Garrett. Thank you.
Thank you, Mr. Lear. Mr. Roberts, your reply.
Thank you. Again, in summary, the nature and severity of these acts is egregious. This is the highest degree of moral turpitude. Public protection is of the utmost importance. It is the #1 priority of the board. Due to the nature and severity of these acts and the fact that the respondent has not shown overwhelming proof of reform, has no plans in place to continue his reform other than his own self-discipline, the decision needs to be modified and the petition should be denied to protect public safety. Thank you.
Thank you, Mr. Roberts. Dr. Cosgrove, you do have an opportunity to address the panel regarding penalty if you wish to do so. Do you wish to address the panel?
Yes, I would.
Okay,
thank you.
So hang on one second. I need to place you under oath. So if you would raise your right hand, please. Do you solemnly affirm that the testimony you will provide in this will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, go ahead and put your hand down whenever you're ready, sir.
Okay, well, I thank you for the opportunity to address the board, and obviously to the board, I want to thank for giving me the opportunity to practice medicine again. This is a huge opportunity that a lot of people had doubts that I would do well, and I think I've done very well. So thank you also to Mr. Lear for representing me. So since 2006, I've been, a model citizen. I've done everything I can to redeem myself. That was a dark period that Mr. Roberts talks about, where I was out of control. My behavior was, outrageous, but it was a very short period of time that was due to, I was not acting myself. So that's not my normal character. I was under the influence of drugs. I've addressed that issue, and I've been off drugs for 14 years. Yes, self-directed. And I think that's important to say that, it's not because people are watching over me that I'm off of drugs. I was off of drugs for 4 years before I even started the NA meetings. NA was helpful, but it also was something I had to do to document for the medical board. If I just came to the medical board and said, I'm fine, I've had no kind of counseling. I've done nothing like that. That would never be credible. So while I was off drugs for 4 years, I went to NA for another couple of years. And then I went to Physicians Health and Rehabilitation Group for a period of time. I was doing drug testing before I was required to, and I documented all of that for the medical board. And I've been drug testing ever since. And you know, it's reasonable that I would be drug tested during probation. That's fine. Mostly for me, it's just a way of showing that I'm not on drugs. It's not a way to keep me off of drugs. So, I mean, I hope the record's clear. I've been through a lot of rehabilitation, counseling, workshops, classes, boundaries, ethics. I have letters from all of those classes that show I participated and did very well at them in my participation. He says I haven't gone above and beyond, but it's not true. I've done a lot of volunteer work, and I go above and beyond every day. Every time I see a patient, I don't do the minimum. I do what's at the best for the patient. I have a lot to do besides the minimum in my daily work, and I do that. I reach out to caseworkers. I reach out to insurance companies. I have to reach out to other providers that I've referred patients to make sure that the process of workers' comp, which is a complicated process, you know, set with a lot of glitches and delays, goes smoothly for the patient. I get a lot of satisfaction from being able to help patients. This is like, you know, something that I get a lot of thank yous, a lot of feedback from patients saying, you've been really helpful. I really appreciate the extra work you've done. You've done a lot. And so all of these things, besides that, I counsel patients. I advise patients. All of this is not necessarily part of my minimum requirements, as Mr. Roberts would suggest. I have a spiritual connection that was reestablished after I went to my very low in 2005 and 6. So that's a big strength for me. Obviously, we've documented that I've been practicing medicine for 4 years under some supervision, but a lot of it is without supervision, and I've done perfectly well with or without. PEP is a physician's education program out of UCSD, which is required to monitor my work. So Dr. Searles from UCSD takes a random selection of my charts and reviews them every month. And I see hundreds and hundreds of patients every month. So he's welcome to take any chart and at random. And he says that there's been absolutely no problems with any of my documentations or my standard of care. I've had no complaints from patients or from any law enforcement in any other regard. So, you know, I love practicing, I love helping people, and I want to do more. I'm limited in what I can do because of the probation. I'm not allowed to have my own business, so I'm not allowed to be creative and, you know, bring in different methods or modalities for helping the community, which I think I have a lot of plans to do.
Dr. Cosgrove, you hit the 5-minute mark, so if you would kindly bring your comments to a conclusion, sir.
I sure will. So we know I've been drug tested for 7 years and clean for 14 years. We have at least four counselors or psychiatrists, psychologists. Dr. Leffler is the psychologist I was seeing on probation. He recommended I don't even need to continue with my counseling. And the medical board agreed. So in February of 2020, they said, yeah, counseling's fine. You don't have to do that anymore. So even the medical board themselves has already agreed that I don't need counseling. So I've been reliable, fully compliant, a good clinician, a law-abiding citizen, drug-free, and a stable model citizen. So I'm eager to get back to regular work and continue that trend without any kind of monitoring. I think it's gone on long enough. Thank you.
All right, thank you. I'll turn it to the panel to see if there are any questions. And since we're not together, what it might be easiest is for me just to go down the list And then after I go down the list once, I'll double check to make sure new questions haven't popped up by anyone else, any of the other panel members. So first, Dr. Lewis.
Yes, I have two questions of Dr. Cosgrove. And they may be able to be rolled into one. So what the medical board looks for is commitment to their treatment programs. And by that, I mean a continued awareness that they had a problem. The problem needs continuous monitoring, and to demonstrate to us that you have taken this seriously. So when I look at the sobriety programs, I don't really see in there now, today, that you have made an effort to continue with AA or NA as you move forward, because although I'm not experiencing those programs, there are relapses years in the future. And also, I don't see evidence of really your own decision to maintain some psychotherapy, even if it's once a month. So I wonder where that went. And yeah, just because the medical board agrees you don't need this, you don't need that, it's your own person who says to yourself, God, I just need to keep doing this. You know, I just think that that is the healthiest thing for me to do. Could you respond to that, please?
Yes. Well, okay, so I did sort of already respond to that when I said that I had already stopped using drugs for 4 years before going to NA. So that was a period of time that was helpful, seeing other addicts talk about their problems. I related to it for a while, but I feel like I outgrew that. I already understand. I've come to terms with it. I've done a lot of self-reflection, and I get it. I'm totally aware of the consequences of drug use and substance abuse. I mean, who could be more aware than me? I mean, it completely destroyed my life, my career, almost destroyed my family. It destroyed my reputation. I'm pretty aware of the consequences of drug use. And if over this last 14 years, I wanted to sneak some in here and there, I could have, I'm sure, I guess. I'm not interested in that. I'm interested in the future. I'm interested in a clean life, a respectable life, and a successful resolution in the next 10, 20 years to my career. So do I need ongoing counseling? Well, I don't think so. And neither do any of the psychiatrists or psychologists who have, counseled me. They all agree. So I'm not a counselor in that regard, but we got 4 professional opinions that say I am adequately stable to go on without counseling. So I think that's significant. And no, I don't want to keep going to counseling for the rest of my life. And no, I don't want to keep going to drug classes for the rest of my life. I'm already at a point where I'm past that and I'm moving forward. And yes, I'm very safe to do that.
Okay, thank you for your response.
What was that now?
Thank you for your response to my question. I appreciate
you. All right.
Candor.
Mm-hmm.
Any further questions, Dr. Lewis?
No, no further questions from me. Thank you.
Thank you. Dr. Hawkins, any questions?
Yes. Thank you. May I proceed? So we're aware increasingly there's a physiopsychological basis for drug addiction and drug abuse. My question, Dr. Cosgrove, is do you ever have cravings for amphetamines? Current time, present.
No, not at all. In fact, the idea repels me. It's it gives me the creeps. When you're on amphetamines, you crave amphetamines. And once you're past it, you know, I quit on my own. I didn't go do any kind of a, you know, a program to cleanse my body or anything. I just quit because I hated it at the end of the use of it, actually. By the time I quit, I was like very done with it. And it was just an impetus when I hit rock bottom and was arrested that I'm like, good God, I'm done with this for now, forever. And no, I've never wanted to go back. I have nightmares about using it. I wake up going, good God, I'm glad that was a dream, you know, because I don't crave it, not at all.
Thank you. No more questions.
Ms. Lubiano, any questions?
Yes, one question. Can you hear me okay?
I hear you well.
Thank you. I read in the briefings that one of the reasons that is driving your desire to terminate the probation conditions is your desire to be with your family and move to Texas. And I was wondering if you could elaborate on that a little bit. For example, is your intention to not practice in California again and move on up to Texas if the restrictions are lifted?
Well, yeah, I want to get back with my family because I feel like I've missed a big piece of their life, right? So during the period of time I was on drugs, I was missing some of their life. I mean, I was there for them, but not in the same way I could have been. And then after that, you know, I've been tied up with this whole procedure for 14 years. Meanwhile, my kids have grown, gone on to college, graduated college. My son's in medical school. So yeah, I would like to get back with my family. My wife is in Texas. She has a good paying job. She's unable to come out here and work because of that. She's like, doesn't want to give up a good career. So yeah, what we will do after I'm off probation is not 100% clear. We all make plans, but you know, do we stick to them or do we change our plans? My plan right now would be to continue working in California for probably 6 months or so until I'm able to establish, you know, some opportunities to be able to transfer. I have to sell my house, my job, give notice, find a new job, get a license in Texas. But yes, eventually we think Texas would be a better place for us. I'm a lot more mobile than my wife is, so that makes sense for me to move than she. And I think that's what we'll probably plan to do.
Got it. Thank you. No further questions.
Okay, Mr. Warmoth, any questions?
Yes. I think when, at least for my part, when we decide on a period of probation, it's not the amount of time that we think it's going to take to accomplish all the rest of the terms and conditions. It's the amount of time we think it's legitimate that we need to monitor someone. And I understand that there is reason to shorten that, but for me, it needs to be going above and beyond meeting the limit, the bare minimum requirements of probation. You mentioned earlier about doing some volunteer work. Could you speak a little bit more about what type of volunteer work you're doing and the extent of it?
Okay. Yeah, I've done all kinds of different things. I worked at the food bank in New Braunfels, Texas for a period of time. The NA meetings was volunteer work because I became a leader in the group of the regional and of our independent meeting place. And, you know, try to connect. I work at, have helped at the church. I've done some Sunday school teaching, you know, where you, you know, sort of like a substitute. I'm not like a full-time teacher there, but I've been there for the church, for the children. And, you know, when you say doing the bare minimum, I have to comment that the bare minimum in this case is a lot. There's this is a lot of elements to this probation, and keeping up with all of it has already, I mean, I'm not saying that I shouldn't do more, and I always will do more, but to minimize the extent of what the probation is requiring of me, I think is understating it. So yeah, I've done various community service things, but right now what I'm doing is focusing on my work. And so I mostly work about 50 hours a week at the clinic, and I just try to take care of my spiritual life and my physical health. That's really what I'm doing in the last few months.
Thank you. I did not intend to minimize the amount of work that we are requiring of you. All I can say about that is that it is based on what we thought the seriousness of the original problems.
Oh, absolutely, I understand.
But I appreciate your comments. Thank you. That's all.
Oh, thank you. Mm-hmm.
Watkins, any questions?
Good morning, TJ Watkins here. Good morning, Mr. Cosgrove.
Good morning.
4 questions that I have that jumped out at me as I was preparing for this meeting. This was that this accusation was filed in 2007, right? You were in 2006, and you 2008 your license. You didn't. Right. You surrendered it. You didn't wait for the board to take proceedings, and then in 2008, and in 2011, you filed for reinstatement. You strike me as very confident. So here's my question: do you think you were ready to be back practicing as a doctor in 2011 already?
You know what? At the time, I thought it was going to be some struggle, but I was ready. I would have had some learning and some developing to do. But now, 9 years later, I am confident. I am already practicing and doing well. So yeah, at that time, I could have done it, and there would have been a learning curve to get back on my feet. But in 2020, we've already gone through that learning curve under the supervision and on probation, and I'm fully confident now.
So here's my second question. As a leader in Narcotics Anonymous, there is 12 steps, right?
Right.
Can you tell me what's your favorite step? And also, specifically, what have you done with step number 8?
No, I can't tell you specifically what I've done with step number 8 because it's been several years since that, and I don't have them all aligned in front of me, but I might be able to if I had them listed.
No
but, yeah, my favorite step basically is to give up your power to a higher power, give up yourself to a higher power and admit that you've got a problem and you need help. And also to share with other people what you've done and how to learn from that. And so that's what I've done. And at that time, I had 2 other NA participants who asked me to be their mentor, and I was happy to do that, and they did well as well, as far as I remember now. I mean, it's been 5 years. I haven't been back to those meetings because they were in Texas, but.
So the number 8 was to make a list of all persons we have harmed and become willing to make amends to them all. My 3rd and 4th question, I'm going to make it different. We've all talked about your addiction And we've played a lot of on that as a cause for behavior, right? But this,
Yes.
the behavior was a sexual violence against women behavior. So here's my, what have you done? What have you learned to demonstrate to myself what you have learned, the triggers for that behavior? And if you, and it's not just amphetamines, it's not just the drugs, because a lot of people do drugs and then they don't go beating up women or this behavior, violence against women. So what have you learned in all of this time? You speak about how great you've done on your rehabilitation, and with such confidence that it almost makes me red flag it. So what is the discoveries that you've made about yourself that drove those behaviors?
So what have I done to discover in myself the reasons for my behavior? Well, you know, I think I've gone to a lot of counseling and discussed that with my counselors. And so that has been something I've done. And I've looked back on my life to see where did this come from. And, you know, it's hard to say because I was always a calm and a nice kid growing up. I was always a normal student growing up and through college. And then not until I got on to methamphetamines did this erratic behavior come out. Some of it, I think, was a result of the frustration that, you know, so methamphetamines do have a sexual component. They drive people to be hypersexual. This is well documented in the literature. This is well documented in, I mean, in gay communities, a lot of people will go to these, you know, they have their activities and it's meth driven. So yeah, there's a hypersexuality associated with methamphetamines. And during that time, my judgment wasn't good. So when patients would be flirtatious or admiring of me, I would suck that up. And then when they would make advances, I would be, you know, with my poor judgment, I'm like, okay, there's something I could do with my hypersexual, you know, nature. And then, so, you know, one thing would lead to another, and I would end up having this relationship with a patient. And this happened on 3 occasions. But, you know, once you're there and then they start talking about trapping you, reporting you, you become panicked, you become frustrated. And with the amphetamine high and the poor judgment already, you're like a trapped, you know, animal or whatever. I kind of overreacted, obviously, and freaked out without any feeling for an escape or a rational way to deal with the situation because I had already dug myself in. So, I mean, do I have an explanation other than a panic reaction? Not really. I haven't been violent before. I was never violent after. Those are just one incident with each person, and that was the end of the situation. So I don't have a history or a pattern of being violent with women. I've been with my wife for 33 years, and I have no history of violence with her. I mean, we have a wonderful relationship. This is my, you know, my first bride from 20 years old. We've been together through all of this, thick and thin. And there's obviously in any relationship, there's going to be some hard times. I've never had any violence towards any other women. So I don't really agree that I have a propensity for violence towards women at all. I mean, I've dealt with that. I mean, that was again, that was something that happened in a very short period of time, 14 years ago, 15 years ago, and it hasn't happened since. There hasn't been any propensity toward that for a decade and a half. That's a pretty good track record. That's all I have.
Mr. Watkins, do you have any further questions?
Mr. Watkins, you're back on mute. Go ahead and unmute.
So here's my final question. My final question is that you are not in Narcotics Anonymous, that you're giving up therapy because everybody says that you are ready to go and you feel that you are ready to go. And yet the thing that you cannot explain to us is that the drug addiction, that you fell into it, that you don't understand. But when you fell into it, it turned violent. That risk has not been mitigated to me personally, and unless you have a insight into it. I'm genuinely wanting to understand your insight about what drove this behavior, and now moving all the obstacles. It's like an athlete, we stop training and then we wonder why we become unfit, and that's what you're suggesting. So that's my final question. Thank you.
Okay, I didn't recognize that as a question. Can I have the gist of the question? I didn't quite catch what the question part of that was.
The question part of it is removing, saying, I don't want to be accountable. I don't want to continue the sobriety. I don't want to do any of that. Is what you've I understood you saying up to now. My question is, if we remove that, you still do not understand what dropped you into the narcotics use that resulted in the violence. That creates a immediate concern for me. So if you can explain that, that's the question.
We're going to go into my psychological history from my childhood up until 40 years old. It's going to take a little while, but we can try. I was raised by a single mother in a family in Orange County, California, where my father would carry a gun. He was a motorcycle guy.
Excuse me, this is Dr. Lewis. I'm going to have to interrupt just a second. Sean, can I have a time check, please?
We're at 9:35. Is that what you mean?
Yeah, and how much more do we have for this session?
We are already, we have 10 minutes left till we are scheduled to go into the open session for the second case, but we've not yet deliberated.
Okay, so panel members, just please keep track of that time, because those attendees on the outside will be allowed back in, and we haven't even finished question and answer period, nor have we had final deliberation. Okay.
Dr. Lewis, we haven't gone into closed session, so no one's been removed from the meeting. Before we go into closed session and excuse the attendees, we will, calculate a time from that period. But yes, we do have a full agenda, and we started a little late, but we're running a little over. So.
Okay, so sorry, that's my point. I just want to make sure of the time, since we have a tight schedule. So go ahead, Dr. Cosgrove, continue. Sorry for interruption.
Okay, so I grew up with a single mother and 2 older sisters and 2 older brothers that were out. My older brothers had moved out by the time I was 8 years old, because I was the youngest. And so I was raised, my 2 sisters dropped out of high school and both became pregnant. My mother was a school teacher who wasn't, school teachers back in the 70s didn't make a lot of money. Maybe they still don't. My father didn't pay child support. So the people in my life, my role models, used drugs. My brother dealt drugs for a while. This was my environment growing up. So where did my history of my frame of reference for drug use come from? I think that tells where that came from. I dropped out of high school. I went back to night school. I got my GED. I got my diploma. I went to junior college for several years. I went to the university. I finally decided I'd go to medical school. I went to 2 more years of classes. I got straight A's. I was very dedicated. All this time, I'm a changing person, right? So I went from this kid who dropped out of high school with long hair, smoking pot, to a time when I'm a serious college student, a serious medical student. I was married at this time. I had children. And I was well into just starting my career. I was all credentialed and ready to go. I was feeling proud of myself. I was feeling pretty high on my accomplishments, having gone through where I came from to where I was. And I sought some hedonism. I relaxed. I lost my way. I rejected my spiritual upbringing. I was an atheist for a while. I thought I had it all. It was on me, and I knew how to live, and I was going to live it up. And that was after about 12 years of marriage. So, you know, I was looking for some adventure with my in my life, and we started using pot again. We started meeting people who brought amphetamines into the house. It was insane. It was like a terrible, it was like a movie, but it was terrible because it was me. And after things started rolling and were out of control, the pieces started falling on me. So, and that's when I had to, and then, you know, people are making accusations of me. I'm getting in trouble. I'm getting caught. I'm getting exposed. It was terrible. So I hit bottom, and I reestablished myself in terms of how did I get here? Why did this happen? Who am I? Where am I going? All of that is in my history now. I'm 56 years old now. And so I'm not the same person I was when I was, you know, 15, 25, 35, or even 40. I've learned from my past. I've developed, I've matured, I've moved forward, and I've moved on. I mean, I'm pretty self-aware now. And if you say I seem very confident, and that's a red flag, you know, what would be a worse red flag? Being unconfident and being, you know, so I'm confident. I feel like I'm very ready to go. I'm strong in this. I counsel people in lifestyle. I counsel people in approach to problems. It's what I do every day. So I have a lot to say to patients because of my own history. If I had never gone through that, maybe I wouldn't know what I was talking about. But I feel like I do know what I'm talking about now just because of the trials and the things I've been through. I'm a different person. So moving forward, I'm pretty confident I can stay out of harm's way. I've seen what it does.
Dr. Yip, do you have any questions?
Yes. I have a 2.5 question. Half already touched on by Mr. Watkins about the violent behavior. Just a quick answer would be good, Dr. Cosgrove. When was the last time you had some type of anger management counseling or psychotherapy regarding the anger in the past or now?
Well, my anger issues were 15 years ago, and I haven't had any anger issues since then. So I haven't had any specific anger management classes. I didn't have any before applying for my license reinstatement, and I haven't had any since. But I haven't had.
Fine. That'd be great. So, second question is that have you tried to apply for the license in Texas at all? My understanding, you can still apply. They may put you in probation like California. Have you tried to apply and denied it, or have you ever even started trying the application process?
I inquired about the application process prior to being reinstated, but not since then. At the time, I was told there's no way they're going to give me a license until I resolve my issues with California. So I proceeded to request reinstatement, and I went through all the steps that were required to do that, and I haven't checked back with them until I'm off of probation. I will reapply at that time.
And the third question, before the third question, I want to congratulate you on being able to turn your life around. I think you should be proud of yourself. The third question is that listening to all the board members today, one of the major concerns is how would you move forward with stress ahead moving and getting new lights, etc., to deal with the stress factor that you may have problem with drugs or behavior again. Would you plan on whatever the outcome today that you're going to engage yourself in some type of activity like an NA and a psychotherapy on a regular basis just to make sure you don't turn back dark days?
No, I wouldn't be interested in that. The reason is because if I was living on the edge and I felt like I had a problem with drugs anymore, if I felt like I turned to drugs for stress, then I might do that. But I don't turn to drugs for stress. I turn to exercise. I turn to God. I turn to my family. I turn to my support group, which is my friends and the medical community, other doctors. There will be some stress, but I'm used to stress. I go through stress all the time. This whole process has been stress. I'm steel forged. I'm iron forged into steel now. I'm not about to crack under the weight of having to sell my house or find a new job. Those are pretty low-level stressors compared to what I've been through. So I think I've held up pretty well for 15 years. I can handle.
Great, thank you. No further questions. Thank you.
Yes, sir.
Okay, any further questions from any of the panel members? All right, hearing none, this concludes oral arguments. And so the record is closed in this matter. The matter is submitted and we are off the record.
Good morning, everyone. It's about 10:20. Open session is now back open. I'm seeing attendees starting to rejoin the meeting now. I'd like to give them a few more minutes to get everyone back into the room. But at this time, I'm going to start promoting the interested parties for the second case, just to get that out of the way. But if you could all remain on mute until called out by Judge Wong, I would appreciate it, but this will save us some time here as we go forward. So I have Nicole Hendrickson. I have Rebecca Wagner. And I have Mr. Lee. Dr. Lee has not joined us yet. So I would like to give everyone maybe 2-3 more minutes here to rejoin. The numbers are coming up to the numbers we left with. But maybe just a few more minutes. It's only 10:21. So I'll be back in 2 minutes. Okay, good morning again, everyone. Have all the interested parties for the second case now promoted into the panelist category. So just so it's clear, at any point during the oral arguments, anyone in the panelist category can unmute themselves and speak at any time. If there's any objections from either side, please feel free to unmute yourself at any time and to make those objections heard. With that being said, I'll turn it back over to Dr. Lewis, who can get us started on the second oral argument. Thank you.
Okay. This is Ron Lewis, MD. I'm now going to open the open session on oral argument on the non-adopted proposed decision on Dr. Quinn Lee. And I have the pleasure to turn the rest of this meeting over to Judge Wong. Judge Wong?
Thank you, Dr. Lewis. Madam Court Reporter, if we could go on the record. We are on the record before the Medical Board of California, Department of Consumer Affairs, State of California, in the matter of the accusation against Quinn Lee, MD. It's MBC number 800-2016-028347. It's OAH number 2020-040-350. My name's Quorum Wong. I am an administrative Office of Administrative Hearings. This is the date and time set for oral argument and the notice of hearing for oral argument. In light of Governor Newsom's Executive Order N-29-20 dated March 17th, 2020, oral argument is being conducted as a WebEx event with the attorneys. And it looks like Dr. Lee is also present by video. I'm present as well as the court reporter by video, with everyone appearing by audio only. First, to establish a quorum for the record, and since the panel members do not have video, I ask that each panel member answer audibly after I call his or her name. First, Dr. Lewis.
Present.
Dr. Hawkins.
Here.
Lubiano.
Here.
Mr. Warmoth.
Here.
Mr. Watkins.
Yeah.
And Dr. Yip.
Here.
And let the record reflect that a quorum is present. Next, I'll ask the attorneys to state and spell their names for the record, starting with the Deputy Attorney General.
Wagner, R-E-B-E-C-C-A, Wagner, W-A-G-N-E-R, Deputy Attorney General.
Nicole Hendrickson, counsel for Dr. Quinn Lee. My name is Nicole-Hendrickson.
Thank you. And as I previously mentioned, let the record reflect that Dr. Lee is also present. So just to reiterate to the attorneys, you both have the ability to unmute yourself in case there's a need to object. I am also monitoring the video feeds. So when you object, if you also want to raise your hand or sometimes somehow give me a visual cue, I will hopefully see that as well. So the board in this matter has issued an order of non-adoption of a proposed decision by an administrative law judge and has decided to determine the matter itself. The board has expressly limited argument to the question on whether the proposed penalty should be modified. The following process and time limitations will apply. First, Ms. Hendrickson will have 15 minutes to make an opening argument. Then Ms. Wagner will have 15 minutes for a response, followed by 5 minutes by Ms. Hendrickson for a closing argument, and last 5 minutes by Ms. Wagner for her closing arguments. These time limits will be strictly enforced. The argument shall be based only on the existing record and shall not exceed the scope of the record of duly admitted evidence. No new evidence will be heard. I remind the panel members that they may ask questions of the parties to clarify arguments, but should not elicit new evidence that is not already in the record. I or a panel member may ask a party to support his or her oral argument on a particular matter by making a specific reference to a citation in the record. At the end of oral arguments by counsel, I will offer Dr. Lee an opportunity to address the panel regarding penalty if he desires to do so. And if he does, then I will place him under oath, and he will have no more than 5 minutes to address the panel. And then after oral argument, the board will go into closed session to deliberate. The parties will not receive a decision today, but will be receiving a decision later in the mail. I should say after argument and any comments by Dr. Lee, the panel will have an opportunity to ask questions. Oral arguments are being recorded stenographically by a court reporter who, of course, is at a different location than those who are speaking. Therefore, it's important that everyone identify himself or herself each time before speaking, and that they speak slowly and clearly. We ask that you mute your microphone when not speaking, and of course, remember to unmute it before speaking. Also, keep in mind that the rustling of papers can be picked up by microphones when your microphones are live. Again, I want to remind the parties that all arguments must be based on the existing record and no new evidence will be heard. Additionally, the board has had the benefit of reading your briefs. And with that, Ms. Hendrickson, if you would like to begin.
Yes, thank you. I want to say good morning to everyone and thank you for the opportunity to be heard on this matter. We're here today because the issue in this matter is whether or not a penalty should be imposed. As you all know, the ALJ heard the matter over the course of 4 days and determined that a penalty should not be imposed and that the accusation should be withdrawn. So I kind of want to reiterate for you how that decision was made and what happened over the course of those 4 days. So to begin with, the medical board did not meet its burden of proof, and that's really what's at issue here, that the evidence, the record did not show that the medical board met the burden of clear and convincing evidence. Now, I want to kind of discuss each day and what happened. On day one, we heard from the medical board's expert. The medical board's expert was extremely confusing, cagey. One of the things that the medical board made in its written brief was that it stated the issues in this case are actually quite complex and cannot be explained in simplistic terms. I actually disagree with that statement. The issues in this case are simple. And what happened was that over the course of the medical board's experts' testimony, it was confusing to really decide what is she trying to say. Oftentimes her testimony would change. She would say one thing and then say, well, yeah, but I didn't consider that, or I did consider that. The medical board is trying to say now that he was incompetent. Not only is that not in the accusation, but this is based off their medical expert saying, well, if we were to believe the mother, but yet in her own report, she says she didn't believe the mother because of so many inconsistencies. So at the end of it, I like to go through, and I did this in my brief, but I just kind of want to reiterate the point of each one of the issues that she found and why we don't agree with her findings. So documentation and history. Her basic point is that we need to have qualifiers. There is missing information in the chart. For example, where is the location of his back pain? That is one thing that she tried to say. But yet, if we go to the physical exam, we see that the back pain is in the lower back. So she's saying, well, it should have been in the medical history. It was in the chart, is the point. She's saying, well, there's missing information, for example, a family history of diabetes. 2 medical providers spoke with the patient and a mother. The first being the patient himself, and the second being Dr. Lee. And neither one of them documented that the patient had a family history of diabetes. Now, the mother wants to say over and again now that she did tell the physician this, but yet 2 providers are saying, no, if this was told to me, I would have documented it. The mother's testimony herself is, respectfully, she lost her son and she's upset. And we understand that this was a tragic case of a 16-year-old boy that shouldn't have died. That's just the fact of the matter. He shouldn't have died. It's not fair. But at the same time, the information she's telling is constantly changing. One moment she tells us that Dr. Lee she tells the investigator, Dr. Lee asked what he had eaten that day. At hearing, she says, no, that never happened. He never asked what I ate. So I understand she's upset, but memories fade. So while she wants to be adamant that she told this information, the truth is she doesn't remember a lot of what happened. But what we do have is the medical records, and we have 2 providers who didn't document. The expert next said, well, let's see, that there was documentation in the physical exam, that was inadequate because she found that simply checking the boxes was not enough. So the problem here that we have was bias from the board's expert. She has used this particular form in the past, so she's familiar with it. She worked at urgent cares. And she said, well, you need to add qualifiers. You can't just check positive or negative. And in fact, she even stated at one time during the hearing that she didn't believe the information in the chart because she can't assume that he actually checked those, that he actually examined those systems because he only documented negative or positive. Had he actually added more qualifiers, then she would have believed that he actually checked those systems. So that's huge. There's a lot of assumptions on the part of the expert. There was also, she talked a lot about the heart exam. Now, one of the problems that we have, because the issues were made to be quite confusing, is there's a lot of, well, he should have talked about the sinus rhythm. He should have documented the heart rate. He should have noted an improvement in the heart rate. All of these are one issue, the heart exam, and whether or not Dr. Lee's heart exam was within the standard of care, not this documentation, that documentation. It's all one issue. So let's talk about the heart exam. This patient came in with a elevated pulse. We all know that. So why was there no documentation in the chart of improvement? Well, there was 2 documentations. The first being the actual exam itself. Dr. Lee noted that the heart rate was normal. Okay, why did he document the heart rate was normal? Well, because this is a grossly obese patient, 378 pounds, I believe, who came in. It was a 100-degree day, August in Sacramento. He was in a lot of pain, 10 out of 10 pain, he reported. He was nauseous. He had just vomited right before his vitals were taken. And he was hunched over. There was a lot going on with this patient. And so Dr. Lee then checks his heart rate and he finds that it's below 120. And so the question is, well, is a 120 or below normal in an obese patient with this presentation? And the answer is yes. Even the board
interpose an objection. May I interpose an objection?
You may.
Okay, sorry. I believe she's stating evidence that is not in the record, claiming that Dr. Lee found a heart rate under 120. I just interposed that objection.
Ms. Hendrickson, your response?
It's in his interview and he testified to it, Your Honor.
Ms. Wagner, anything further?
No, Your Honor, I'll save it for my argument. Thank you.
Okay, so the objection's overruled. Ms. Hendrickson, if you please continue.
Thank you. So the question then is, well, is up to 120 normal? And both the medical board's expert acknowledged that it would have been for a patient with this presentation, as well as Dr. Lee's expert said the same thing. So then the question becomes, well, how do we know that? Shouldn't he have documented some sort of improvement in the heart rate? Yes, he should have, and he acknowledges that. Repeat vitals should have been taken. He understands that. Dr. Lee had a policy in place. Part of what wasn't in the ALJ's decision that was in the record is that these medical assistants go through a lot of training at his office. And so with the training in place, with the fact that this medical assistant had been working for Dr. Lee for several years, he had no incidents before that with this medical assistant. He had no reason to believe that repeat vitals wouldn't have been taken. It was a documented policy in place. And so should he have documented improvement in the heart rate? Yes, repeat vitals should have been taken. It's one issue. It's not separate issues here. We're talking about a diagnosis of dehydration. Their expert over and over again reiterated the point that dehydration should have been diagnosed in this patient. However, Dr. Lee, the patient comes in with possible symptoms of dehydration, and dehydration is on Dr. Lee's differential diagnosis. However, he then performs a physical exam, and on his physical exam, there are no findings of dehydration. The mucous membranes are normal, the eyes are normal, skin turgor is normal. There's no evidence of dehydration. So while the medical board's expert insists that dehydration should have been included in the diagnosis, there was nothing on the physical exam to corroborate that, which is why even though it was initially on his differential, it eventually was dropped from his differential and not ultimately his diagnosis for this patient. Orthostatic vitals was another issue. This patient came in with 10 out of 10 pain. He's almost 400 pounds. Doing orthostatic vitals is nearly cruel, frankly, in this case. It's an outdated test that most providers don't even do anymore because it's so unreliable. And in fact, the expert even said that had his, actually, I withdraw that. Next is urinalysis. There's a lot of discussion on why more testing wasn't done. Why wasn't a urinalysis done? Why wasn't blood work done? And this is a huge part of this case. And the answer was, it wasn't indicated. Dr. Lee testified at hearing that he went through the medical history with the patient. He testified that forgive me, I'm trying to open a screen really quick. I apologize. All right. So I asked him during the hearing, what did you ask the patient when you saw him? And he said, quote, I looked at the chart and the chief complaint for him to come is back pain. So typically ask, where is the pain? How long the pain has been? Anything make it better? Anything make it worse? And what kind of pain? Sharp or dull pain? Whether the pain is constant or comes and goes, and how much pain he has from 0 to 10. I ask him associated symptoms, review of systems, fever, chill, cough, abdominal pain, nausea and vomiting, or diarrhea, urinary systems, burning, frequent urination, any injury to the back, any pain in other body parts. These are all questions that he asked the patient. And we can see in the chart that there's documentation answering these questions. There's then the question of, well, why didn't he document no urinary complaints? Why didn't he document everything here, the entire review of systems that's on the right side of the chart? And the answer is because it's not his custom and practice. What typically happens in his office is this. Typically, the medical assistant takes the patient's vitals, then asks about current complaint and asks about everything on the left side of the chart, which is why are you here? What's your pain level? How long has this been going on? All of which is in this chart. Medical history, anybody with associated, any injury. Then what happens is on the right side of the chart, it's a pre-printed form and it shows a review of systems. Typically, the medical assistant will go through this review of systems one by one. In this particular case, it wasn't done. And so the question becomes, why wasn't it done? And the answer, we don't know for sure, but what the evidence in the record was this. Dr. Lee had seen the patient go to the bathroom. He heard him violently vomiting. The patient then came out of the bathroom, went into the exam room. Dr. Lee then finished up what he was doing and testified that he went into the room. That is not typically what his practice is. Typical practice is that the medical assistant would come out of the room, put the chart on the door, and he would look at the chart, see that it's all filled out, and then go into the room. In this case, he went into the room. So the insinuation, and we don't know for sure, was that he interrupted the medical assistant while he was taking his history. The medical assistant then handed Dr. Lee the chart, and Dr. Lee then went through the history again. So on a typical occasion, this would have been filled out. Now the question then is, well, is that the standard of care? No, the standard of care is to do a review of systems, which was done in this case. A review of systems was done. We have the complaint. We have a history of the complaint. We have pain levels. We have frequency. We have the amount of pain the patient was in. All of those things are documented. So that is where the standard of care is. Now, would it have been better to have more information? Absolutely. Nobody disagrees with that. More information would always be better. But this can't be a case of hindsight where the patient died and now we're looking backwards and going, well, you should have asked about urinary system, or you should have documented no urinary symptoms. If we were looking at something else, this patient was paralyzed because he came in with 10 out of 10 pain and Dr. Lee didn't order imaging, then that's what we'd be discussing. Why wasn't imaging ordered? My point is, we can't look at this as a case of hindsight. We have to look at this in real time. What did the patient present as? What did Dr. Lee have in front of him? Now, the next question, well, how do we know he asked all these questions? The mother corroborated it herself. She told the investigator that he asked what the patient had eaten that day. She said that to the investigator. Now, she might have not said it at hearing, but the mother's memory is...
Ms. Hendrickson, you've reached 15 minutes.
Okay.
So, Ms. Wagner, your opening argument?
The board in this case did prove the matter by clear and convincing evidence. And there's two main points I want to make sure and reiterate to the board today. Number one, the proposed decision does not accurately reflect the evidence that came before the board. And number two, the proposed decision is inadequate to protect the public in this case. The 16-year-old patient came to see Dr. Lee and he was desperately ill. He came with his mother. He was so weak, he needed help getting out of the car. He needed help walking inside of the urgent care. He was vomiting quite actively. He was so suffering from such excessive thirst that his mother had to stop on the way to the urgent care to buy him a gallon of water, which he guzzled down and still brought into him in the urgent care to be treated, and had that water with him when he was with Dr. Lee. He had every single vital sign there is, all four of them were abnormal. He had 142 pulse rate. His blood pressure was 164/94. His respiratory rate was high, and he had a low grade temperature. All of the vital signs that were checked, all abnormal. He also had the severe back pain, 10 out of 10, and the nausea and active vomiting. He also had symptoms of dehydration, vomiting, diarrhea, the fever with an elevated heart rate. And despite all of these very serious symptoms, the constellation of all of the abnormal vital signs, respondent did not give the patient a simple blood test. He did not give him a urine test. He did not take and document repeat vital signs. The records show that his pulse rate was 142. That's what the records still show. Either he didn't take repeat vital signs or he didn't document it. But there's not any in the medical records of the urgent care records. He also did no fluid challenge and took no orthostatic vital signs. All he gave the patient, who later had to be hospitalized within 9 hours after being seen by Dr. Lee, all he did was give him a shot for the back pain that he hadn't yet to figure out what was causing that, a 10 out of 10 back pain. and he prescribed anti-nausea medication that the mom had to pick up at a pharmacy outside of there. He diagnosed the patient with food poisoning and non-infectious gastroenteritis without any documentation in the medical records as to why he believed it was food poisoning. What had the patient eaten that could have caused food poisoning? Did any other family members have food poisoning? The medical records in this case were severely deficient. As I've already indicated, there was no repeat vital signs prior to the discharge documented in the medical records. There was no documentation that the patient's tachycardia had resolved. There was no documentation regarding what the patient had eaten, as I indicated earlier. So the teenager was sent home with his mother, so weak he could barely walk out, actively vomiting, with all of his vital signs abnormal, and told to go home. He went to the hospital within 9 hours, and he died within days of complications of undiagnosed diabetes. And this was despite the fact that, as the mother testified at the hearing, Dr. Lee was told that her other son had diabetes, that the patient's father had diabetes, that there was a family history of diabetes on both sides of the family, and that she had high blood pressure. It was despite the fact that the patient had excessive thirst, and he was drinking right in front the water in front of Dr. Lee. And instead, Dr. Lee told her that the back pain was from the patient throwing up so much, and that was what was causing it. He also implied at the hearing that he just simply believed that because he was overweight, that was causing the back pain. And I think he also said the higher blood pressure. The mother's testimony in this case, which disturbingly is not described at all in the proposed decision, not even mentioned that she testified, much less that the testimony was evaluated or compared with any of the other evidence that corroborates her testimony. Her testimony is essentially uncontroverted as to many of the facts, because Dr. Lee doesn't remember what happened, and the medical records don't show the things that the assumptions they're making about what did happen. For example, the most serious, that Dr. Lee believes that the heart rate must have dropped to 120, or he would have documented that. But there is no documentation that anybody even took a repeat vital, nor is there any documentation of what that repeat vital was. And even if it was 120, 120 is still an abnormal pulse rate. So her testimony, my point being, is essentially uncontroverted because Dr. Lee doesn't remember what happened. And yet, incredibly, the proposed decision does not assess the mother's testimony or even say that she testified. Excuse me, I'm doing the page turning thing. So the board's expert testified, and it seemed that both the judge and counsel, as they indicated in their argument, very much attacked the board's expert based on style issues, whether they thought her report was written a certain way, or how she testified. She had never testified before in a hearing. She was not a professional witness. She's a doctor, and she tried to listen to the questions and answer them the best she could with her information. But you can tell by just looking at Exhibit 7, the urgent care medical records, how seriously deficient the treatment and care and documentation was in this case. There's extreme departures for failure to document related to the standard of care. There's multiple departures in this case, many of them extreme. And of most concern is the failure to consider cohesively that every vital sign was abnormal and that there was significant tachycardia in this case that was not addressed. In addition, there is concern that both of the experts acknowledged that Dr. Lee seemed to think that the temperature could be explained based on the heart rate, as if the temperature made the heart rate higher, which is a lack of knowledge and shows a violation of the standard of care for Dr. Lee. And yet the proposed decision essentially disregards the expert's opinion or testimony on superficial reasons, over style, over substance, and faulting her for not testifying before. The respondent's expert, on the other hand, is a highly polished, highly paid professional witness who, as Exhibit 16 shows in the record, was highly edited in his report with great consultation with counsel as to what the report should say and how it should be phrased and how many departures there should be, until he crammed all of these problems with the treatment in this case into one single simple departure regarding lack of documentation. But even he agreed that the documentation was deficient. He was forced to base his conclusions regarding that based on what Dr. Lee must have done. He must have done a repeat vital, and he failed to document, even though it doesn't say that in the records, and even though 120 would still be abnormal, even if we believe that. The proposed decision isolates one phrase from the board's expert and attaches great significance to the issue, claiming that the board's expert didn't understand the standard of care and didn't testify properly about that. And that's simply not true. And we've documented all the things the board's expert said, both in her testimony and in her report in our brief, if you should choose to review that. There are extreme departure based on the fact that all the vital signs were abnormal. He did not take a repeat heart rate. He did not ensure that the patient was stable. And the medical records are an extreme departure all by themselves for the standard of care. Medical records is not like a technical violation. They are an important part of the standard of care that's given to a patient. And yet, despite all this overwhelming evidence, the proposed decision finds no cause for discipline and dismisses the accusation. The medical records alone are very seriously inadequate and are a key component of the standard of care. The proposed decision ignores the weight of evidence in this case, and we do believe that cause for discipline exists. The disciplinary guidelines in this case, in a case like this, would call for 5 years of probation. Because this is a single patient case with no prior discipline, we are recommending instead 3 years of probation, a practice monitor, a clinical competence assessment program, medical record keeping, ethics, and education. And these are requested in order to protect the public. As we sit here today, we have no idea if Dr. Lee has improved his record keeping, for example. There's no there's no practice monitor been in place. There's no record keeping monitor in place. The ALJ seems to be very impressed with the fact that eventually Dr. Lee did take a medical record keeping course, but based on the care that was provided in this case and the concern for the public protection, it seems that the only appropriate decision is that discipline is appropriate. The board has proven this case by clear and convincing evidence, and that 3 years of probation with all the usual monitoring would protect the public in this case, and that the proposed decision simply did not accurately reflect the weight of the evidence that was admitted before the board. Thank you.
Thank you. Ms. Henriksen, your response.
Yes, thank you. I want to readdress the mother's testimony. The board is saying that the testimony was uncontroverted. I think that is a misrepresentation of the record, in fact. And even the board's own expert acknowledged that the mother wasn't credible. She talked in her own expert report about why she didn't consider the mother's statements because of all the discrepancies she had given. And this is located in Exhibit 7, AG 0094. In 2 spots, she specifically states in the consumer complaint and interview, the mother described her recollection of events. She said the subject never asked the patient's history or if he was diabetic, that he, quote, asked what the patient had eaten, but not taken an inventory of the diet or medical history. Although she confirmed that her son had no past medical history, nor was he taking any medications, as was listed in his visit note from that day. She states that her son had drank a gallon of water on his way to the clinic and that she informed the subject about this, as well as a family history of diabetes, and this was acknowledged. However, per the chart note, none of the history is listed, and Dr. Lee did not mention these items during his interview. Dr. Lee states in both his summary and care response in the interview that an appropriate medical screening was done, and he was denied as having any chronic, the patient denied having any chronic or inactive medical conditions nor taking any medications. She also acknowledged that the patient's mother claims she told the subject and her son that her son had drank a gallon of water immediately prior to arriving at the clinic. But the Sutter records state that polydipsia, which is excessive thirst, was denied. And this is in multiple places in the Sutter records. Another issue is that the board wants to highlight Exhibit 16. Let's talk about Exhibit 16. This was supposed to be a response by Dr. Wood to a subpoena for all records. Now, our office provided the Deputy Attorney General with thousands of pages, or about 500 or so pages of records here. And that is not what showed up at hearing. What showed up at hearing was 48 pages. And what it came out to be was this: 48 pages that were in no particular order. No one was able to identify what document came with what email or what we were looking at when, who wrote a certain document. And not only that, the most offensive of all, the most offensive of everything was that the Deputy Attorney General represented this exhibit to be the documents that were provided by Dr. Wood, and they were not. What happened was the Attorney General's office took these documents, manipulated them.
Objection. Misstates the evidence outside the record.
Absolutely not.
Ms.
It is
Hendricks,
in the record.
Ms. Wagner, your response?
Where is it in the record? It's not in the record.
This is going to count against my 5 minutes, Your Honor. It's on page 5.
Your Honor, I'll save it for argument. Let her just go ahead. Thank you.
Okay.
So the Deputy Attorney General admitted that someone in her office had taken this document, put it through some sort of program, and this then showed red line on the document. All I know was that they weren't the documents that were produced to the board. I mean, to the Deputy Attorney General's office. So there is absolutely no evidentiary value to these documents. They were manipulated by the Attorney General. They were not produced in the same way that they were not produced at hearing the same way they were produced to them. And there's absolutely no value to it. We don't even know what we're looking at. And so if we talk about the board's expert, the DAG highlighted that the ALJ only referred to one thing that the board's expert said about the standard of care. Well, let's talk about that real quick. The board's expert testified on the first 2 days of hearing that the standard of care was something which is a standard that she holds herself to, is essentially what the ALJ said. So on day 3, what happened was the expert came out to testify. And now for the first time, she used a reasonable person standard. And when I asked her about that on cross-examination, she said that she admitted she had a conversation with the Deputy Attorney General, went back, looked at the disciplinary guidelines, refreshed herself on what the standard of care was, and that's why her testimony changed.
Ms. Hendrickson, you've exceeded 5 minutes. So, Ms. Wagner, your final response.
Thank you. I just like to reiterate the point. The true issues here in the case are the standard of care was violated. The proposed decision does not accurately reflect the evidence that was before the board, and that the proposed decision is inadequate to protect the public in this case. I don't want to get too sidetracked by other issues which appear to be attacking my integrity, the board's experts' integrity, the patient's mother's integrity. I will point out that innocent misrecollection of witnesses is common. If that's what counsel is pointing out, some inconsistencies, that's very common, especially obviously in something that had happened under great trauma. But the point is that the board's, the proposed decision does not even acknowledge that the patient's mother testified about any of these things, or weigh that testimony against the evidence. So the weight of the evidence is against the proposed decision in this matter, and discipline is appropriate to protect the public. And I just want to point out, although it's not really relevant to this and it's more a personal attack, is this issue of Exhibit 16. The board, or the Attorney General's office, was provided documents from counsel that were from their expert, Dr. Woods, and they gave us all the documents, which were their paper documents, and we simply clicked on, as you can with the Word document, you click Show Edits. If you've ever had someone edit your writing, you put Show Edits, and it showed all the edits on there that counsel had made to their experts' written report. The attorney was making edits to the written reports of their expert. And all that can be done not in altering evidence, as they made it sound that the Attorney General's office would do such a thing. We took the documents that they had electronically given us, we checked Show Edits, and it showed all the edits of the attorney essentially writing the expert's opinion in this case to ensure that it fell within the very small category of one simple departure in the standard of care. And that's simply not what happened in this case, and we would urge the board to reject the proposed decision in this matter as it goes against the weight of the evidence. The board has proven this case by clear and convincing evidence, and we ask that the public be protected by placing Dr. Lee on probation with appropriate monitoring. Thank you.
Thank you. Dr. Lee, you have the opportunity to address the panel regarding penalty. Do you wish to do so, sir?
Yes.
Okay, if you could raise your right hand, please. Do you solemnly swear or affirm under penalty of perjury that the testimony you will provide in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you. You may put your hand down. And so I just remind you, if you'd keep your remarks to 5 minutes or less, and whenever you're ready.
Okay. First of all, I would like to thank you for thanks for the medical board and the judge giving this opportunity to address the case. This is a really sad case, and I feel very bad, very sorry for the mother's loss for the trial. I want to let the board know is that I have been practiced medicine for 20 years. I was trained in internal medicine and pediatrics, and I've been working in the ER for more than 10 years. And after that, in order to help the ER overcrowdedness, and I established the urgent care. That has been more than 10 years. I'm a very experienced physician, and also I'm a very caring physician. I take patient care very seriously. I would say more than my own life. I treat all the patients as my own families. The other thing that we have been really involved in the community services. We not just in the medicine, and also we help the community to we help the city to organize the sport events and help for the job corps to train medical assistants to provide jobs for the underserved populations. And this is a really sad case, and we try to looking back for every step of the case, we still try to improve and try to learn something from it. Personally, I attend the medical record keeping class, and also we train all our staff. We set up the new vital sign policy, and we train all the staff and how to repeat the vital sign and how to do the documentations. I have a big practice in Lincoln. I have over 3,000 patients. Most of them are seniors, and they rely on my care. I've been seeing them every day up to now. And also in the urgent care, we are one of the main urgent care inside Sacramento to take care of the underserved population, underserved medical populations. So I'm begging for the medical board, just give me the opportunity to continue my practice. And I don't want my 3,000 senior patient in Lincoln lost the primary care physician. Because once I'm put under the discipline, and I'm going to lose my privilege to serve those people. So that's one thing I want to address to the board, and I'm pretty confident that I'm safe to practice, and we have been training all our staff, and the whole practice environments and the whole documentations has been improved, and so I try to prove to the board that I will continue to do better, and I try to give please give me the opportunity to serve my patient. Thank you.
Thanks, Dr. Lee. So that concludes argument. To the for questions. First, Dr. Lewis, do you have any questions?
Yes, I have several questions, and respect to my other colleagues, I'm going to try to be brief, and maybe the person I question can be also brief. My first questions go to Ms. Wagner. Ms. Wagner, and Judge, you'll let me know if any of these questions are not in the record, please. You can just stop me.
Sure, and also the attorneys can object as well.
Oh, good, that's fine. Did you, or in the record, or did you have a chance to review the standard operating procedures, or the standard operating procedures for MA, or the operating procedures for the urgent care in your review?
I think I don't know for sure if Dr. Lee's counsel introduced those eventually at the hearing. But I think something related to that was entered, but it may have been that they corrected that and did it after this had happened. I really don't remember the details about that. Perhaps Ms. Hendrickson remembers. There was some documentation, but I don't know if they created that policy after this happened or what happened.
Okay, it's very important to know that, to understand how this urgent care operates, because every urgent care has a different set of SOPs, and also the SOP for the medical assistant, different of what they're.
Would you like me to answer?
Yeah, I'd like to have an answer from somebody.
Yeah, please let me answer. They were at hearing, the urgent cares policies and procedures were under Exhibit Tab D, and what was decided was that the other documents, I'm sorry, no, I apologize. One moment. They were under Exhibit Tab HH, forgive me. So we had the entire clinic's policies and procedures manual. What ended up happening was because it was determined that anything outside of the urgent care policy that was in place was irrelevant to the allegations. Only pages 1, 2, which are the cover pages, which demonstrate that these policies and procedures were in place prior to this patient encounter. And then the patient page 8 was admitted, which was the actual repeat vital policy that was already in place before this encounter. Does that answer your question?
Yes, I think Dr. Lee probably will know even better about what is in place at that urgent care. But I want to finish with Ms. Wagner and then go on to Dr. Lee, if I may. Ms. Wagner, can you just clarify for me? I wrote this down and I want to make sure I understood this. Did you say the increase in temperature cannot increase a heart rate?
We had the testimony from both experts at the hearing. So Dr. Lee had written a letter to the board explaining that he discounted the pulse rate of 142, that it was somehow related to a low-grade temperature of 99.9 degrees. And both of the experts testified that that is not accurate. And so I obviously am not an expert, but they both agreed on that issue, that was not in fact accurate, and that that was, inaccurate knowledge on the part of Dr. Lee.
Okay, I'm going to go on to Dr. Lee, if I may.
Yes.
Dr. Lee, your discharge summaries for each patient that leaves your urgent care, what does it usually say about if there are further problems? What are they supposed to do?
Okay, that based on different scenario, the discharge instruction for gastroenteritis, typically we tell them to maintain the oral hydration, looking for any fever, any abdominal pain. If the condition is worse and they cannot tolerate any fluid, and they go to the emergency room. That is the instruction was given to this patient.
Okay.
And in addition, if I may, sorry, forgive me. I had to move down. If I may. In addition, Dr. Lee provided to the board a complete copy of the discharge instructions that were printed out and given to the patient. So there's a 1-page in the records, which the patient signed that she received these documents. But in Exhibit I, Respondent's Exhibit I, starting on page 5, I believe, just off the top of my head, there's actually another about maybe 6, 7, 8 pages of discharge instructions that were provided to the patient as well. And those documents were never provided to the board's expert before the hearing. So she acknowledged at the hearing that those would have been within the standard of care and adequate. She just wasn't provided them before then.
Okay, Dr. Lee, do you do blood? Do you do blood tests or IV fluids in your urgent care?
We don't do IV fluid, and the blood tests based on the indication. If we need to do it, we can do a glucose check.
Okay, thank you. Let's see if I have any other questions before I move on. You've answered all my. I think you've answered all my questions. So thank you very much for responding to them. I appreciate it.
Thank you.
Welcome.
Hey, Dr. Hawkins, any questions?
Yes, briefly, and for emphasis, Dr. Lewis asked my question of Dr. Lee, and that is, in this urgent care, do you have the ability to obtain blood tests such as potassium, glucose, et cetera? And the answer was yes, you have the ability. That was my only question.
Okay, Ms. Lubiano, any questions?
Hi, can you hear me?
Yes.
No questions at this time.
Okay, thank you. Mr. Warmoth, any questions?
Sorry, no question.
Okay, thank you. Mr. Watkins, any questions?
Yes, I've got one. Good morning, Dr. Lee.
Good morning.
Question is, in the record, the mom disclosed that she told you that about his diabetic status and the family history. And my question is, based on the weight, the age of the patient or would that have been something that we could have reasonably assumed? That's my only question.
Number one, the mom, when I took the history, and the mom denied any past medical history and also any family history of diabetic. So that is the you can see there was document on the chart, and she denied that my question about that.
Thank you.
Okay, Dr. Yip, any questions?
No question. Thank you.
Okay, I've gone through the panel once. I'll check one more time. Any further questions from any panel members? Okay, hearing none.
One more.
Okay, go ahead, sir.
I forgot to ask Dr. Lee, do you have an electronic health record in place at your urgent care?
We use this, you can see that in the record, this is paper template. And after we using this template, we scan to the computer. So this is the system we use right now. And still, that is probably one of the most common documentation system we use in the urgent care.
Okay, and the message for the DAG, is that a legal document in your opinion? I don't know if it's out of the record, but paper copies with check boxes, is that legal?
I think the issue is,
go ahead.
I'm sorry, the issue is that you can, at that time, it was within the standard of care at the time Dr. Lee was using it to use such a form. You can, but you can't only use that and not, document pertinent positives and negative, not document that a recheck of the vital signs, not document tachycardia has resolved. So it's not just because they were a paper form and not electronic, at least at that time, that violated the standard of care. It was the lack of information in the documentation that was wholly inadequate in this case, if that answers your question.
So back to your question, whether it's legal or not, yes, it's legal. It's many urgent care is using it even right now. And you can check on, I would say, more than half of the urgent care right now, we're using the same system. And in terms of the documentation.
Dr. Lee, this is Judge Wong. I'm going to interrupt you. I apologize. This is really getting on beyond the scope of the question, which was directed to Ms. Wagner, and I think we're getting outside the record.
It's been answered. It's been answered. Thank you.
Okay. And just for the record and the court reporter's benefit, those additional questions were by Dr. Lewis. Dr. Lewis, do you have any further questions?
No, I do not. Thank you very much, Judge.
And any of the other panel members have any additional questions? Hearing none, this concludes oral arguments. The record's closed, the matter is submitted, and we are off the record.
Okay, thank you, everyone. We have all the interested parties in the panelist slots for the third oral argument. I still see the public members joining up, but I think we can go ahead and get started back in at 12:02 here. Dr. Lewis, if you want to go ahead and take back over and introduce oral argument 3.
Okay, this is Dr. Ron Lewis. Our next order of business is to discuss the case of Dr. Brian Flores, and this is an oral argument following a remand. And I'll turn this over to Judge Wong.
Thank you, Dr. Lewis. So, Madam Court Reporter, if we could go ahead and go on the record. We are on the record before the Medical Board of California, Department of Consumer Affairs, State of California, in the matter of the petition for early termination of probation of Byron Flores, MD. It's MBC number 800-5017-08435. It's OAH number 2020-040351. My name's Quorum Wong. I'm a Administrative Law Judge with the Office of Administrative Hearings. This is the date set for oral argument and the notice of hearing for oral argument in light of Governor Newsom's Executive Order N-29-20 dated March 17th, 2020. Oral argument is being held as a WebEx event with, looks like I have the court reporter, myself, and Deputy Attorney General Wagner appearing by video, and I have, oops, I see Mr. Garcia is also by video, and Dr. Flores I have by audio only, and then the panel members and the public are by audio as well. First, to establish quorum for the record, and since the panel members do not have video, I ask that each panel member answer audibly after I call his or her name. Dr. Lewis.
Present, Judge.
Dr. Hawkins.
Here.
Ms. Lubiano.
Here.
Mr. Warmoth.
Here.
Mr. Watkins.
Yeah.
And Dr. Yip.
Here.
And let the record reflect that a quorum is present. Next, if I could have the attorneys state and spell their names for the record, starting with the Deputy Attorney General.
Deputy Attorney General Rebecca Wagner, R-E-B-E-C-C-A, Wagner, W-A-G-N-E-R.
Mr. Garcia, if you would unmute yourself and state and spell your name for the record, please.
Yes. Good afternoon, Your Honor. Albert Garcia, A-L-B-E-R-T-G-A-R-C-I-A, attorney for the petitioner, Dr. Flores.
Okay, thank you. Let's see, I got that going. Okay. So the board in this matter has issued an order fixing date for written and oral argument after Superior Court remand and has decided to determine the matter itself. The board's order expressly asked the parties to address the following issues. One, the actual told period of Dr. Flores's probation. Two, Dr. Flores's anticipated probation termination date. And three, whether the board's decision should be modified based on a change, if any, to Dr. Flores's anticipated probation termination date. The following process and time limitations will apply. Mr. Garcia will have 15 minutes to make an opening argument, followed by Ms. Wagner having 15 minutes for a response. And then Mr. Garcia will have 5 minutes for a closing argument, and Ms. Wagner will for her closing argument. These time limits will be strictly enforced, and the arguments should be based only on the existing record and shall not exceed the scope of the record of duly admitted evidence. No new evidence will be heard. The panel members may ask questions of the parties to clarify the arguments, but may not ask questions that would elicit new evidence. I or a panel member may ask a party to support his or her argument on a specific matter with a specific reference to the record. At the end of oral arguments by counsel, I will offer Dr. Flores an opportunity to address the panel regarding penalty. If he elects to do so, I will place him under oath, and he will have no more than 5 minutes to address the panel. After oral argument, the board will go into closed session to deliberate. So the parties will not receive a decision today, but will be receiving a decision later in the mail. Oral arguments are being recorded stenographically by a court reporter who is at a different location than the speakers. So it is important that everyone identify himself or herself each time before speaking and speak slowly and clearly. We ask that you mute your microphone when not speaking. And then of course, just remember to unmute it before speaking. And also the rustling of papers does get picked up on the microphone when they're live. So please keep that to a minimum. Again, I want to remind the parties that all arguments must be based on the existing record and no new evidence will be heard. Additionally, the board has had the benefit of reading your briefs. So with that, Mr. Garcia, you may begin.
Thank you very much, Your Honor. Good afternoon, Your Honor. Good afternoon, Dr. Lewis and other members of the panel. As a preliminary matter, Your Honor, I have a question for you. I did file a document entitled Petitioner's Objections to the AG's Written Argument after Remand. It was submitted to the medical board on May 5th with a request that a copy be forwarded to you and also that copies be forwarded to members of the panel. So I want to inquire at this time whether you received that particular document.
I did not.
Your Honor, we do have an objection. I'm going to be very brief about it. I'm probably going to count toward my argument here, so I'm going to be very brief. We did file a written objection, and basically it says the petitioner, Dr. Flores, objects and moves to strike the declaration of Verdine Richardson attaches Exhibit A to the AG's written argument and any references thereto. And it's based on several matters. The Verdine Declaration and references thereto are beyond the scope of the proceeding and violate, 1, the board's express orders limiting argument to the record, and 2, California Code of Regulations, Section 1364.30. The order fixing date for written and oral argument issued by the board on March 19th states, quote, written and oral arguments shall be limited to the evidence contained in the record and shall comply with Code of Regulations Section 1364.30. The notice of hearing for oral argument issued by the board on April 10th likewise states, quote, arguments must be based on the existing record and no new evidence will be heard. And then the board directs the party's attention to, once again, California Code of Regulations, Section 1364.30. That regulation states, quote, the argument shall be based only on the existing record and shall not exceed the scope of the record of duly admitted evidence. No new evidence will be heard. The panel members may not ask questions that would elicit new evidence. Our position, Your Honor, is that by citing to and relying on the matters set forth in the Verdine Declaration, the board has gone beyond the record, beyond the duly admitted evidence in this case. And so that declaration is in violation of the board's own orders and, of course, the California regulation that I've cited. For that reason, it's a proper argument to which the petitioner objects and moves to strike under the regulation that we've already cited. Petitioner respectfully requests that his objection be sustained and that the Verdine Declaration and all references thereto be stricken from the record. If the panel wishes to hear additional evidence on the tolling issue, it should remand this matter to the Office of Administrative Hearings for an evidentiary hearing under Government Code Section 11513 with its attendant hearing rights, including Dr. Flores' right to cross-examination. All right, that's our objection, and we'll leave it to you, Your Honor, to rule on it subsequently, but at this point, I'll get into the substance of the argument itself. In its judgment, the Superior Court, when granting the petition for writ of mandate, stated, quote, respondent board has not cited any evidence demonstrating that tolling was placed in issue or otherwise part of the fact finding that was before the ALJ at the administrative hearing. The Superior Court then went on to expressly find that, quote, petitioner did not waive the right to contest calculations concerning whether his probation period was told during the time he was undergoing the board-ordered educational program. That's the PACE program. I'm going to repeat that. Whether whether the probation period was told during the time the petitioner was undergoing the board-ordered educational program. That is the pivotal question that informs the answers to the board's 3 inquiries in this proceeding, and Your Honor has already outlined those. Those questions being, number 1, the actual told period of probation. Number 2, the anticipated probation termination date. And number 3, whether the board's decision should be modified based on a change of any to the anticipated probation termination date. Those are the 3 questions that have been posed and posited. Petitioner submits that the answers to those questions, Your Honor, and members of the panel, depend on the answer to the fundamental question posed by the Superior Court, whether the probation period was told at all during the time petitioner was undergoing the board-ordered PACE program. In other words, you don't start calculating, you don't start counting days until you first address and answer that central question. And the answer to that elementary query is found in probation condition number 11. That condition has 2 components that are relevant to this inquiry. First, that condition states, quote, any period of non-practice within California, as defined in this condition, will not apply to the reduction of the probationary term. That's an end quote. But second, that condition also states, quote, for purposes of this condition, condition number 11, non-practice due to a board-ordered suspension or in compliance with a condition of probation shall not be considered a period of non-practice. Now, why was it that Dr. Flores was not practicing medicine from August 28, 2015, the effective date of the decision, and September 12, 2016, the date on which the board determined that he had successfully completed the PACE program? That's the question. The answer is this: he was not practicing during that period of time because he was complying with the condition of his probation, namely that he complete the PACE program as a condition precedent to resuming the practice of medicine. His non-practice, therefore, in quotation marks, non-practice, therefore, to put it in the language of condition 11 was, quote, due to a board-ordered suspension in compliance with a condition of probation, end quote. And as condition 11 states, for purposes of this condition, non-practice due to a board-ordered suspension or in compliance with any other condition of probation shall not be considered a period of non-practice. The problem with complainant's case, and by the way, I have the utmost respect for Ms. Wagner, but the problem with her client's case is that the complainant fails to address the fundamental issue posed by the Superior Court, whether the probation period was told at all during the time petitioner was undergoing the board-ordered PACE program. Instead of answering that question, instead of addressing that question, the complainant puts the cart before the horse and simply starts counting days. But you don't get there. You don't get to that point until you first address and answer the pivotal question of whether there was any tolling at all under the express language of condition number 11. I think the record's clear, Your Honor and members of the panel. The reason Dr. Flores was not practicing medicine during the period of time from the time of the effective date of the decision until he was cleared to practice by PACE, the reason he wasn't practicing was because he was complying with a condition of his probation. It was a board-ordered suspension. And by definition, under condition 11, that does not constitute non-practice for purposes of tolling the probationary period. There has been no tolling of the probationary period in this case, none whatsoever, under the express language of condition number 11. So for that reason, Your Honor, we urge the panel members to look at that condition. It has, obviously, that language has some effect. It wouldn't be there as just mere surplusage. So when the board says non-practice due to a court order, to a board order suspension or in compliance with the condition of probation, that must have some meaning. You can't just ignore that. And I think that's what the complainant has done in this case, not address that particular issue. That language has to be given effect. And the effect to be given to it is the reasonable and rational one, is that Dr. Flores wasn't practicing during that time because he was ordered not to practice. And by definition, that does not constitute non-practice, in quotation marks, for purposes of tolling the probationary term. I'll reserve any time that I still have left for a reply.
Ms. Wagner, your response, and if you would address Mr. Garcia's objection within your response, please.
Yes, thank you. So the issue is, and I think that Mr. Flores might be technically correct about the actual declaration from Verdina Richardson based on the board's order, the way the board ordered it. However, the Sacramento Superior Court remanded this case to the board to address the issues of the tolling period and the anticipated probation termination date. And the only way to do that is to rely on the board's own records regarding the probation status, which we attempted to advise the board about through the declaration of Verdina Richardson to explain the exact tolling periods in the board's record. If you discarded Verdina Richardson's affidavit, then the issue would be the evidence before the board as it is, which would give Dr. Flores no tolling credits because the probation report that was entered into evidence during the hearing said he had a tolling period of 495 days. And that's the evidence that the ALJ found in the proposed decision. We later figured out while writing the writ that that is inaccurate, that we did not give him enough of the days of his tolling period. And he, in fact, was to have only 369 days of tolling. So the declaration is assisting the board in reviewing its own records to determine this issue, which was sent to the board on remand from the Superior Court of Sacramento. So there is essentially more than one way the board can establish about its, to establish the evidence about its own record. The board, it sounds like maybe this is what Mr. Garcia would prefer, could send the case back to the original ALJ. They could take additional evidence and establish the tolling period and the issues. But it doesn't, it would just waste time for Dr. Flores in this issue to be heard, which is the record that the ALJ heard and at least mentioned in his proposed had the incorrect tolling period of 495 days. And since then, as was described and in Verdina Richardson's declaration, explained the exact dates. If we relied only on the record, then all we know is that we do have in the record that Dr. Flores testified that he began work, I believe, in October of 2016, October 3rd or something. So we know that that period of time can be credited towards him because the 495 days the board had told is less those months after he started work. So for October, November, December, those months will be added and are not appropriate for the tolling period. So it's a bit of an unconventional place we're in, but that's the issues. But the board can't decide the issues on remand without considering its own records, which showed that the tolling period was really for 369 days, and the anticipated probation date is September 21st, 2021. And the real issue then is to reweigh or to consider that, in fact, he did have these additional 3 to 4 months of practice that the ALJ did not know about in making his decision to deny the petition for early termination of probation. It's a bit confusing, but there's no way to, the actual issue on remand is whether to establish the tolling, the probation termination date, and then determine whether that changes the board's decision in the case. Now, Mr. Garcia is arguing a different issue, which is really his issue on the writ, which is he is arguing that those tolling days are wrong, the ones that were already established in the record, because the condition precedent, that Dr. Flores didn't have to meet his condition precedent of satisfying, successfully completing the PACE program in this case. So he's kind of mixing up a different issue that he would like to raise, but I think that issue is more an appellate issue at this point, because the ALJ has already issued a proposed decision about that. In some, that issue was already brought before the board, and it's not the issue on remand. But nevertheless, Mr. Garcia is arguing that Dr. Flores was suspended and that non-practice time doesn't count. Well, he was not suspended. He just had as a condition precedent to beginning to start work again after not practicing medicine for between 6 and 7 years after his license was revoked for serious and varied causes of discipline. He had not practiced for many years and then was given the chance to be on probation and to have the condition precedent, going to PACE, making sure he was up to date on his skills, which there was a lot of concerns that I've outlined in my brief about his performance at PACE, which isn't surprising. He wasn't practicing for more than 6 years. So of course it wouldn't make any sense to have a probationary period start when we aren't even able to monitor his practice, because he's not allowed to practice until he completes the PACE program. So that doesn't make any sense, because the whole point of probation is to ensure that the public will be safe, that we can monitor Dr. Flores during the times he's practicing. Otherwise, he could run off to Tahiti for 4 years and come back and practice for the last year of his probation and say, okay, my probation ran out. So it's non-practice. And in this case, it was non-practice because he hadn't successfully completed PACE, and he didn't get credit. The board didn't know that he had started practicing, and so their numbers were off. But once we knew the numbers, then we've calculated it in Verdina Richardson's declaration, which does meet an exception to the hearsay rule, the general hearsay rule, by being a custodian of the records, of the business records and government records of the board, which explains the actual tolling and the probation anticipation date. So I don't know how much time I have left, but the real issue is, does the information that the tolling period was off by these days and instead it was told for 369 days, does the fact that he was actually practicing for 4 more months than the board knows change the decision of the board as to whether or not to grant the early termination of probation? And it is our opinion that the proposed decision should not be changed, because of all the factors that are important in considering whether to grant an early termination of probation. There was a long period. First of all, his original discipline from May of 2008 was very serious and varied. It was gross negligence in the care of multiple patients, dishonesty and corruption in allowing unlicensed persons to examine children at his clinic and allow them to prescribe medicine to the children using pre-signed prescription forms.
Your Honor, I'm going to object. I mean, there were 3 issues that were raised here by the board. 3 questions, and Your Honor outlined them at the very beginning of this argument. And now we're going back to why the doctor was placed on probation in the first place. Well, that's not the issue. The issue is the 3 questions that were posed by the panel or the board to be addressed in this proceeding. And this goes beyond those issues.
Ms. Wagner, your response?
Well, you can't, the third issue on remand is whether the board's decision should be modified based on the change in the tolling period, because the original ALJ had a slightly wrong tolling period. And so the decision is, do these extra few months of practice that the board did not know about change the board's opinion? And then you have to weigh the same factors that are to be decided when you're deciding whether or not to grant an early termination of probation. Those are, what was the original discipline about? How many years was he not in practice? How, and also, while I'm mentioning that, he also had criminal convictions.
Okay, you're going beyond the scope of the objection. So, Mr. Garcia, any response with regard to the objection?
I'll submit it, Your Honor. Thank you.
Okay, so the objection's overruled. The argument thus far will stand. Ms. Wagner, you may continue.
Okay, thank you. And the other part from the 2008 discipline was that he had facilitated false Medi-Cal claims, and these resulted in criminal convictions. So there was a variety of different discipline that was imposed originally, which is one of the factors to consider in this type of case. In addition to the many years he wasn't practicing medicine at all. And then in addition, we had evidence at the hearing regarding his performance at pace, which I've outlined in my brief, and I won't go over that again. And he also had part-time work. He was working part-time once he started on October 3rd. That period of time when he was working was part-time. And the decision found no clear and convincing evidence of rehabilitation warranting the early termination of probation. So, and the opinion is that, our opinion is that the underlying conduct was so serious and varied, that factor doesn't change based on, just because there was a few more months of part-time work that we now know about. And he was not in practice until more than a year after his reinstatement. That was one of the factors the ALJ put on. So for more than a year, he wasn't in practice. So that period should be told. And that fact doesn't remain changed, other than the board did give him an extra month in July for that. And the basis was this limited time in practice that was another factor the ALJ listed as a basis. And the only thing that has changed is that these few more months of part-time work were not considered by the ALJ. So the issue is, does this change the board's opinion about whether the early termination of probation should be granted? The anticipated probation date is September 21st, 2021. And we believe that the petition for early termination of probation should be denied, and the tolling period should be set at 369 days. I'll submit it.
Mr. Garcia, your closing argument.
Your Honor, do I have any additional time from the my opening remarks?
You have 5 minutes, a total of 5 minutes to do a closing.
So I can't reserve any of the time that I didn't use up on my opening statement?
No.
All right. The issue here is this. Counsel really mischaracterizes the issue. The issue that was raised, one of the main issues that was raised in the Superior Court, was this very issue of whether condition number 11, with the language of that condition regarding non-practice, whether that language means that during the time that Dr. Flores was in the PACE program, that did not constitute non-practice for purposes of tolling the period of probation. That was an issue that was directly before the Superior Court. The Superior Court considered that issue and ruled, again, petitioner did not waive the right to contest calculations concerning whether. Here's the issue, whether, and again, complainant does not address this issue. Whether he was, whether the probationary period was told during the time he was undergoing the board-ordered suspension, the board-ordered educational program. So that's the issue. The Superior Court address that issue. That issue was raised in the Superior Court. It was briefed, it was argued, and the Superior Court says, we don't have a determination of whether this period of probation was actually told during the time that Dr. Flores was in the PACE program. And that's why it was remanded. Figure it out. Was it told or not? If it was told, how many days was it told for? But you can't ignore the Superior Court's order here. If you do, and you issue a decision after remand, that decision is going to go back to the Superior Court. He's going to review it, and he's going to decide whether you complied with his order. You have to make that determination. Now, Ms. Wagner says, well, he wasn't suspended. Well, the language of the condition says suspended or you're not practicing because you're suspended or because you're complying with a condition of probation or because you're complying with a condition of probation. What was the condition of probation in this case that kept Dr. Flores from practicing? The condition of probation was do the PACE program, complete the program, complete it satisfactorily as a condition precedent to resuming practice. So that during the time you're in PACE, you can't practice. Dr. Flores is complying with that condition. That comes directly within the language of condition number 11 here. That does not constitute non-practice because the reason he was not practicing was because he was complying with the condition of probation. And again, you get into numbers, calculating numbers, but you don't get there until you make that determination on that pivotal question. It's a central question. It's the fundamental question. All the answers to the three questions posed by the board depend on how you resolve that elemental issue. Was there tolling during the time that Dr. Flores was undergoing the PACE program as a condition of probation? That has not been answered. And so now we're going back to, oh, he was a bad doctor, he got probation. Well, that's not what we're here for. We're here to answer these three questions. And the reason we're here is because the Superior Court said, you didn't decide this issue. You didn't determine it. It has to be determined now. And it's not just a matter of starting to count days. You can't start counting the days until you actually address and answer that pivotal question, whether there was any probationary tolling at all during the time that Dr. Flores was doing the PACE program. And I'm not just making that issue up. I'm relying on the language, the express language of condition number 11. It must mean something. That's why it's there. You don't just write provisions of a condition of probation for the fun of it. It has an effect, and it means something. If the non-practice is due to either a suspension or a compliance with a condition of probation, that does not constitute non-practice for purposes of this condition. So there's no tolling. The doctor was complying, and that's the reason he wasn't practicing. And so all the other arguments about calculating and getting it right or getting it wrong, that is completely, you don't get there until you answer the fundamental question, and the complainant has failed to address that question. I didn't hear one comment that had to do with the interpretation of the condition number 11. And that's why we're here on remand. We have to decide what that means and how it applies in this case. Otherwise, we're going to be back here again in a few months if the decision after remand does not address that issue. Thank you.
Thank you, Mr. Garcia. So, Ms. Wagner, your response?
With all due respect to Mr. Garcia, we simply disagree as to why the issue is here on remand. The judge in Sacramento Superior Court, because of our brief that we had filed in Sacramento, we notified the court that although the proposed decision has, the tolling period of 495 days, that the board had discovered that date is inaccurate. And the judge's ruling was, well, I can't reassess the decision as to whether or not early termination of probation. I can't make the factual determination of the correct tolling period based on based on in the writ, that the board has to make that decision. It's a factual issue that we made an error, that was an error in the record. And it's on remand to determine the correct number of tolling dates. And that's why it's on remand. Now, counsel is bringing in this other issue that he also would like to argue that his original tolling period is inaccurate because he's claiming that he didn't have to complete the PACE program, which it clearly states in the probation order. He cannot start practice until he has the condition precedent of successful completion of the PACE program, which makes common sense. We're not just going to let him start practicing medicine after 6 years without practicing medicine. Count that towards his probation when he hasn't even successfully completed PACE and is having a lot of troubles in successfully completing PACE. So it doesn't, he would like it to say that. He would like the board to make that determination. I don't think that's the issue that we're here for. The issue is to set the correct tolling days and to reweigh whether that changes the board's opinion, which is exactly what the remand order says. And the reason why the judge brought that up is because, in fact, the tolling period was incorrect that the ALJ relied on based on the discovery that he had been practicing for a period of time we didn't know about. So I'll submit it to the board on that.
All right, so before I check with Dr. Flores to see whether he wishes to address the panel regarding penalty, I'll go ahead and rule on Mr. Garcia's objection. I'm sustaining his objection to the declaration attached to the Attorney General's written argument, which is the declaration of probation monitor Verdena, Verdena Richardson. So the sustained and the declaration will not be considered. So Dr. Flores, do you wish to address the panel regarding penalty?
Yes, Your Honor.
Okay, before you do, if I could have you raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you will provide in this matter will be the truth, the whole truth, and nothing but the truth? Okay, so you could put your hand down, and I just ask that you keep in mind that you're limited to no more than 5 minutes. And with that, whenever you're ready.
I am ready, Your Honor. I am ready. Good day to everyone in the panel, Your Honor. I just feel privileged that the medical license was reinstated to me. I know I do not have the right to practice. It is a privilege. I do not here to deny what very wrong things happens in professional life. I recognize those. I am, and probably I will pay for those mistakes. The reason for which I was working only part-time is not my decision. It's because most of the times, because my past, because my current medical board probation status limit my positions available out there. You are not going to believe that even as a volunteer with the state of California, living in these bad days of the virus, even these people say, no, Dr. Flores, thank you. You cannot volunteer with us to help the other sick people in the state. So that and so happens when you are under probation, limit my possibilities of working normally. I do recognize I did wrong. I take multiple ethical, professional, medical hours of studying. I now recognize, I'm able to recognize the red flags that led me to my mistakes. I'm not denying anything, not before, not now. And probably I have to disclose this for the rest of my life. Every time I apply for a job, for hospital. I'm going to go with this baggage. I have to live with that, but it's very difficult for me, for my family to survive in this environment. I hope not so, but the things are going to be a little bit more difficult to everyone. Please just release me for this probation. I know I did. I know I can do better. I am doing better. Mrs. Richardson, my probation officer, she is in contact with me all the time, and she can back it up.
Okay, thank you, Doctor. So now I'll turn it over to the panel for any questions. First, Dr. Lewis, do you have any questions?
No, I do not have any questions, Your Honor.
Dr. Hawkins, any questions?
No, I do not.
Ms. Lubiano, any questions?
No questions from me. Thank you.
Mr. Warmoth, any questions?
No questions.
Dr. Watkins, or excuse me, Mr. Watkins.
No questions at this time.
Dr. Yip, any questions?
No questions, thank you.
Okay, one last opportunity. Do any of the panel members have any questions? Okay, hearing none, this concludes oral arguments in this matter. The record's closed, the matter is submitted, and we are off the record.
Okay, we're now in open session. 5, 4, 3, 2, 1. Okay, now we're adjourned.